Welcome back to the channel. Today we're diving into a courtroom clash that unravels almost immediately. This case centers around a defendant who refuses to cooperate, an attorney desperate to withdraw, and a judge who has reached her limit. What begins as a routine hearing quickly turns into a tense standoff over something as simple as reviewing bodycam footage. The defendant's behavior triggers a complete breakdown in the attorney-client relationship, forcing the court to intervene. Watch closely, because the escalation in this hearing reveals exactly how fragile a defense strategy becomes when the client refuses to listen. Let's begin.
Mr. Du Bois, you do not.
Okay, so I don't have a right to be heard in respects to why he's withdrawing?
No,
Because
he's telling bailiff, let's get him out of here. I'm not doing this. This is case number 253691 FY Appearances Counsel.
Joanna Kerry for the people.
Troy Dean, Your Honor, appearing with Mr. Du Bois.
And we are here for a couple matters. We're originally scheduled for a preliminary examination, and then yesterday afternoon, the court received the defense's motion to withdraw as counsel. So let's address that issue first. Mr. Daniel.
Yes, Your Honor. I went to go speak with Mr. Du Bois yesterday at the Western County Jail. We attempted to go over the 3 hours of body cam videos with him. There was a disagreement as to how to go about viewing the videos, and that Mr. Du Bois then became upset and told me I could leave. And I said, okay. So I started to leave, and then he started calling me names, calling me a hack, calling me a bitch, all the way to the point where he was let out back to his cell. I believe there's been a breakdown of the significant breakdown of the attorney-client relationship pursuant to the Michigan Rules of Professional Responsibility 1.116. I don't believe I can accurately represent Mr. Du Bois in the future because of his attitude. And again, what he wanted to do, it made it really untenable to go through the process of reviewing the videos. And consequently, I feel that I have to excuse myself in the case, so that's why I filed the motion to withdraw, Your Honor.
And just so I'm clear, you believe that you can't continue to represent Mr. Du Bois because of the breakdown? All right. Ms. Kerry?
This is where the judge shifts into a more direct and assertive tone. When she says she's beginning to see a pattern, she isn't speaking casually. She's identifying repeated behavior, the defendant's refusal to accept guidance, his insistence on controlling the process, and his ongoing conflict with appointed counsel. Judges watch for these patterns because they affect courtroom efficiency and the integrity of the legal process. Her remarks make it clear that Mr. Deo's approach is undermining his own defense. What do you think? Is this a valid concern from the judge, or is the defendant simply frustrated with the system? Share your thoughts below.
I'm beginning to see a pattern here, Mr. Du Bois, and that's, no, I won't say the pattern I'm seeing. But I did see in Mr. Daniel's motion that you, at least as he stated, told him that you work for me and you're going to do things my way. That's not how that works. You're not an attorney. You might think you have the legal training, but based on what I see from your criminal history, your understanding of the law has not bode well for you. So I suggest you start taking the advice of the attorneys that are appointed to represent you, because we are now, I don't know how long it's going to take to get you an attorney. I had planned on today not granting the motion, but based on what Mr. Daniel is telling me that he cannot work with you because the attorney-client relationship is broken down so much, I will grant the request. I'm sorry to the people. I think we're back here for your third time now with witnesses. I apologize. But I will grant the request. I will let Mr. Daniels out of rep. No, you and I went round and round last time. We're not doing this.
So I don't have a right to address?
Mr. Du Bois, you do not.
Okay, so I don't have a right to be heard in respects to why he's withdrawing?
No,
Because
he's telling bailiff, let's get him out of here. I'm not doing this.
Your Honor, if we may approach the withdrawal.
You may.
What do you mean stop? Nobody's acting aggressive or nothing.
Thank you.
What stop it?
So we're gonna have to shackle you from the floor. Okay. Knock it off. So.
Doesn't want to see the part where the cop says pretend, and we're just
No.
playing evidence.
No,
Nothing.
All right, Mr. McDaniel, or I'm sorry, Mr. Daniels, I have signed that order. Ms. Kerry, I have a Deputy Harold in the waiting room. I assume that's for you as well. So I will bring him in. So
And with the judge formally approving counsel's withdrawal, the hearing concludes on a serious note. This decision emphasizes how critical cooperation is between a defendant and their attorney. Without trust and basic communication, representation becomes impossible, and the entire legal process slows to a crawl. Now the court must appoint yet another attorney, which only prolongs the case and places additional strain on court resources. If this hearing surprised you, or if you've seen similar breakdowns in other cases, let us know in the comments. And if you found this breakdown helpful, make sure to like the video, share your thoughts, and subscribe for more in-depth courtroom analysis and legal commentary.
and